and the ATF, through a backdoor, has set these rule changes in motion, much of this being facilitated outside the appropriate rule change petition protocols. President Biden's decision to treat pistols with stabilizing braces as short-barreled rifles under the NFA was done without congressional approval and clearly indicates how gun control lobbies in this administration wish to force their restrictive agendas on Americans. I, along with my colleagues, believe that the ATF has overstepped their bounds, that they are usurping congressional authority with its rulemaking. Leave the business of making laws to Congress. I want to ensure that you, Mr. Diddlebach, understand that. We'll go back to the schoolhouse rock days. Who has the power to make laws in the United States?
Statutes must be passed by Congress of the United States.
Excellent. Has Congress explicitly criminalized the use or possession of pistol braces under the Gun Control Act?
Congress delegated.
Have they explicitly
delegated to ATF rulemaking authority?
Director, we can do this dance all day long, but has Congress explicitly criminalized the use or possession of pistol braces under the Gun Control Act? Yes or no?
Congress created the short-barreled rifle as a category that wasn't banned or criminalized, but
we're talking about the Gun Control
restrictions.
Act. But again, have we defined pistol braces under the Act, and have we criminalized the use or possession of them? No. The answer to it is no.
The pistol brace itself alone is not the subject of any rulemaking. It's the short-barreled rifle that's created.
My question is, have we done that? The answer is no, because you can't point to it. You can't point to a statute that has that. Has Congress explicitly authorized the regulation of pistol braces under the National Firearms Act?
Our positions, which are set forth in legal briefs, say that we believe we are acting within our regulatory authority as delegated by Congress on short-barreled rifles.
Correct. So 10 years ago when this came forward, and the ATF sanctioned the creation of and use of pistol braces. Those have been outlined pretty extensively.
That was an individual product. The way it works is people submit an individual product. Many different products beyond that have been produced and used since that time.
In reliance on ATF's guidance, right?
You can't have one thing classified and then say you're relying on it and you change the product and say, and that's what was going on. People were saying that things had been approved by ATF that had never even been presented to ATF.
Director, how many pistol braces are owned by American citizens?
So we don't regulate the brace itself, so I don't know, but the estimates in the rule name a number that is far lower than the number that I hear others saying. And one of the numbers.
What would you say that in your estimates?
I would have to look at the rule, but I think it's in the rule. It has an impact estimation, and I don't want to misstate it. I believe it's several million, but I'm not sure.
Several million. Okay, so we can at least agree several million, according to the agency.
You'd have to check the record on that.
We can at least stipulate to that. With implementation of this rule, obviously we've gone through that. You either have to surrender your weapon, you have to disassemble it, you have to destroy it, turn it in, or what happens? You're subject to criminal penalties. Is that correct?
So you have to either. By the way, we've waived all taxes on this during the period of time. There's no taxes. You can either disassemble the brace from the weapon. The weapon still works as the way you bought the weapon.
But hold on, back up. I'm going to reclaim my time for a second. So the agency for 10 years has allowed this to come into being, has sanctioned the existence of and the implementation of and the furtherance of these pistol braces into the marketplace. And now, with at least several million, as you stipulated to, now they want to clamp down on that. And my problem is I hear the snickering and the sneers from the crowd at some points today, and they might think it's funny, but I'm concerned about average, everyday Americans who aren't aware of this rule, who are now going to be turned into felons, subject to up to a $250,000 fine. I think it's ridiculous that we're even here, Director. And I think the mission of the ATF is not in compliance with what you're actually doing with this rule. I yield back.
Thank you, Mr. Fry. Chair recognizes himself for 5 minutes. Mr. Director, I want to remind you you're under oath. Can you tell me, are there any other rules coming down the pipe in the ATF that we need to warn the American consumers that they may be made felons?
So there is a process for rulemaking that's outlined under the APA, and ATF works through and honors that process. And so we consider matters, and when it comes time, we actually publish a public notice of the intent to issue a rule. That's the way we speak about whether we are seeking to enact a rule.
So why now? I mean, the pistol brace has been around for over a decade. Why now?
If one reviews the notice of proposed rulemaking, there is a very detailed this is a transparent process. That's the good thing about the APA and notice and comment rulemaking. We talk about the history of the individual devices that were presented, some inconsistency, which is important to say, and then the necessity to try and clarify for people who want to follow the law which factors are going to make things into short-barreled rifles.
So I'm curious, is there anything coming down the pipe we need to warn our gun owners about, our American consumers, our Second Amendment folks?
Again, when the APA provides for a process, and when there's rulemaking, that we publish a notice of proposed rulemaking, and that then gives the public time to submit comments. We get comments, and we read and review and take into account those comments at that point.
Mr. Drader, can you define an assault weapon for me?
Again, if Congress chooses to take up legislation involving assault weapons, I believe Congress would have two choices. Either Congress itself could write the definition of what an assault weapon is, as happened in Congress in 1994. It's happened, I think, in 7 or 8 or 9 or 10 different state legislatures who have different definitions, by the way.
Okay,
or Congress could delegate to ATF.
Which we probably won't do as long as...
Well, from the tone of some of the questions...
I hope we would never do that. So why is it with... I got limited time. Why would, when you put a pistol brace on it, we have so many people define it then as an assault weapon when we haven't defined it?
A pistol brace...
when it's added to the weapon...
With certain types of pistols, not all, and not all types of braces, can form a short-barreled rifle, which is, Congress set an inch number, right? A number of inches for the barrel, and then it has to be, according to Congress, designed or intended to be shouldered, and that's what the rule seeks to provide clarification on, so we can have a consistent set of objective features of the firearm.
Well, let me say real quick, I went to buy a shotgun a few months ago, and my time expired. I mean, the background check. I finally it expired, and they called me and said, you can come on and get it. So it's not so easy in Alabama to get a gun. With that, Mr. Chairman, I'll yield the remainder of my time to you, sir.
Thank the gentleman for yielding. Mr. Dettelbach, the pistol brace is an accessory, right?
Alone,
firearms.
without attached to anything, the pistol brace is not something that we regulate.
But when it's attached to pistol, it can become a short-barreled rifle, and then it's subject under the National Firearms Act. That's what you're saying.
Depending on the features of both the pistol and the brace. And there are some, the forearm, everybody talks about forearm braces. True forearm braces that are not designed and intended to be shouldered would be classified and not covered.
And the bump stock's an accessory, right?
The bump stock is a conversion device, I believe. So I want to check. Our position on that is in briefs, but that's a different provision of the Act. That's a provision.
When the bump stock gets added to a
converts-
firearm, and that's now subject to the NFA. And
So the NFA specifically says that items which can be used to convert something to a fully automatic weapon are covered by the NFA. So those are the words Congress used. They didn't use the word accessory. They used things that.
And you guys said the bump stock fits that definition and is subject to the NFA, right?
Correct. The bump stock then
And that's been challenged in court, right?
It's currently before the courts. There's a split in the different courts.
It's in the courts. I'm just looking at the one that came out yesterday. Sixth Circuit, one you're familiar with, Sixth Circuit.
Right. The Sixth Circuit, I think, ruled yesterday. A
did.
panel of the Sixth Circuit. There's a prior en banc, and I haven't had a chance to
Let me
review
read,
the
and just tell me if you think, here's what the court said. The viability of competing interpretations is exemplified not only by the myriad and conflicting judicial opinions on the issue, but also by the ATF's own flip-flop in its position. And that's what I think concerns Americans, is you guys told us all one thing, told the country one thing on the bump stock, and then you change. You told the country all one thing on pistol braces, and then you change. And that's the conflict. And on this situation, bump stocks, I don't know how many Americans had that, but my guess is not near as many have had the brace. Now we're talking about a situation that I doubt you've ever been in before, where you're going to make a rule that's going to impact millions and millions of Americans. And that's the problem. That's the concern. That's why you're here talking to us today. Lots of Americans have, that's why there are cases all over the country, because you said one thing and you flip-flop. Not my words, the Sixth Circuit, their words. That's the problem.
Of course, I understand the legal record, and I haven't read the opinion, and I will. With respect to what happened in the prior administration when that rule was issued, of course, I wasn't there and I don't know the details, but our legal position is spelled out publicly as to what the rule that was issued in the prior administration said.
I'll yield back to you. You're the chairman. Your function is chairman. I'll yield back to you to close it out.
That concludes the hearing for today. We thank our witness for appearing before the committee. Without objection, all members will have 5 legislative days to submit additional written questions for the witness or additional materials for the record. Without objection, the hearing is adjourned.
We are here to consider H.R. 2811, the Limit, Save, and Grow Act of 2023, and H.J. Resolution 39, disapproving the rules submitted by the Department of Commerce relating to procedures covering suspension of liquidation duties and estimated duties in accord with the Presidential Proclamation 10414. Good afternoon. Our business today is to consider